My favorite statements. I believe that every government officer in the state of Maine is committing treason. They're not working with a proper oath of office, not one of them, at least not that I've read so far. 12. Treason against this state shall consist only in levying war against it, adhering to its enemies, giving them aid and comfort. No person shall be convicted of treason unless on a testimony of 2 witnesses to the same overt act or confession in open court. I have a whole bunch of people who would testify that the governor has committed treason and that your entire Supreme Court has committed treason. They are clearly working against the preamble. They are not following the preamble. They are dealing with corporations. They are not dealing with the people anymore. That's why the definitions of the word person is altered to be a legal or commercial entity. Section 13, the laws shall not be suspended, but by the legislature or its authorities. I attempted to shut down and suspend the eviction laws and the foreclosure laws with over 20 people in court. We told the court to suspend the law. We are the people. We have that right. If you can have 12 people come together and vote a man's life away and throw him away in jail, certainly 20 people have the right to question the law and suspend it. We did so, but the sheriff of Androscoggin County still came and stole my home. I was forced at gunpoint to leave my house. The judge didn't have an oath of office. Neither one of the judges involved had the mortgage. Neither one of the judges saw a note ever. Section 14. No person shall be subject to corporal punishment under military law except such as are employed in the Army or Navy or in the militia when in actual service in time of war or public danger. Section 15. The people have the right at all times in an ordinary and peaceable manner to assemble to consult upon the common good, to give instructions to their representatives, and to request of their department of the government by petition or remonstrance redress of their wrongs and grievance. Well, I've done that as well, and all they do is ignore it. I even asked the Androscoggin sheriff if he knew what a remonstrance was, and he said he didn't have a clue. So, he takes an oath and swears to uphold this document that I'm reading to you, and he doesn't even know what the words mean in it. Not one sheriff in this state can read this document and know what it says. The redress of grievance, their wrongs and grievances. Your government ignores everything you put in front of them at this point. Section 16. Every citizen has a right to keep and bear arms for the common defense, and this right shall never be questioned. The definition of the word citizen only meant city dweller back then. Today, it means someone who is part of a political community. What it really should say is all of the people. Section 17. No standing army shall be kept up in time of peace without the consent of the legislature. And the military shall in all cases and in all times be in strict subordination to the civil power. We have law enforcement officers today. I've been asking him for 35 years. Can you define the word law? Not one in 35 years has ever been able to define the word law. They're definitely not subordinate to the civil power, and they should be. Section 18. No soldier shall in time of peace be quartered in any house without consent of the owner or occupant, nor in time of war, but in a manner to be prescribed by law. Section 19. Every person, for an injury done him in his person, reputation, property, or immunities, shall have remedy by due course of law, and right and justice shall be administered freely and without sale, completely and without denial, promptly and without delay, which is exactly the opposite of how the court system works today. You must pay for everything. It's to promote billable hours for lawyers. You don't have a government. You only have a bunch of lawyers telling people in government what to do. Section 20. In all civil suits and in all controversies concerning property, the party shall have a right to a trial by jury, except in cases where it has heretofore been otherwise practiced. The party claiming the right may be heard by himself and his counsel, or either at his election. In the state of Maine, they now deny the people the right to have a jury trial or a trial by jury for theft of property and foreclosures. They deny it. Section 21, private property shall not be taken for public uses without just compensation, nor unless the public exigencies require it. Section 22, no tax or duty shall be imposed without consent of the people or of their representatives in the legislature. Section 23, no title of nobility or hereditary distinction, privilege, honor, or emolument shall ever be granted to confirmed confirmed, nor shall any office be created, the appointment to which shall be for a longer time than during good behavior. In other words, we can't have esquires. Esquire is the lowest form of nobility. It's a title of nobility. Section 24, the enumeration of certain rights shall not be impaired nor denied others retained by the people. It is so sad that people think that you could write down all of your rights on one document. So we have other rights. The people have the right to keep and bear arms in the state of Maine, and that right shall not be questioned. Yet your government constantly questions it. This should scare everyone. They don't follow our Constitution. It's time to put an end to that game. It's time to go back to the 1820 Constitution. Let me read you a little document I wrote about 15 years ago called Driver's License Truth Behind the Game. And the reason I wrote this was to show people that this is just a corporate game, and that we as people have rights that supersede this corporate game. The Constitution only authorizes government to regulate commerce. So when you realize they can only regulate commerce, they have to turn everything into a commercial activity to control it. with the ignorance of the people. So this document's called Driver's License, Truth Behind the Game. When the officer came to the window of the automobile, he asked to see my license, registration, and insurance. My reply to him was that I was not driving, and I am not a driver. The officer informed me that I needed a license to drive, so I replied that I agreed, if in fact I was driving. Needless to say, he could not understand the word driver as defined by the Supreme Court of the United States means. Driver, one employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or bicycle, tricycle, or motor car, though not a street railroad car. Now, I've got several law cases that back that up. You find that in Black's Law Dictionary, 2nd edition. I was not a driver driving, as I was not employed in conducting the motor car vehicle I was in. Employed, this signifies both the act of doing a thing and being under contract or orders to do it. I was not employed in conducting the motor car vehicle that I was in, as I was not under any contract and had not been ordered by any competent authority to make me do so. The officer decided to arrest me and charge me with MRSA subsection 1251(1)A, operating without a license, and MRSA subsection 351(1)B. I have no contract with the for-profit corporate State of Maine or Department of Motor Vehicles. I claim the sheriff's deputy, the judge, and the DA are acting as officious intermeddlers in the purported action. An officious intermeddler is a person who confers a benefit on another without being requested, and who therefore has no legal grounds to demand restitution for the benefit conferred. The office of the court and the sheriff's deputy would be transcending the limits of their authority, as statutes must be narrowly construed, otherwise they would be void for vagueness, as well as expressio unis est exclusio tarius. That which is expressed is included, and that which is not is excluded. The rule of statutory interpretation that says that if something is mentioned as being included, then anything that is not mentioned is by implication meant not to be included. This is a rule that all courts must follow. Clearly defined in the State of Maine statute, Title 29A, this court can only adjudicate an action against a person. Wherein it states in Chapter 1, General Provisions, subsection 101, definitions, adjudication means a finding by a court that a person has committed a traffic infraction, and includes the acceptance by the clerk of the Violation Bureau or any judicial division of any answer of not contested. So clearly they can only adjudicate against a person. Number 54 under their definition of the word person. Person means an individual, corporation, firm, partnership, joint venture, association, fiduciary, trust, estate, or any other legal or commercial entity. Or any other legal or commercial entity with the meaning that all associated words prior to are all legal or commercial entities. Therefore, the word person and the word individual is a legal or commercial entity. Furthermore, I could not have been operating anything as defined in the statute that I am accused of, as I cannot be an operator, as that is defined in MRSA 29A General Provisions, definitions. Operator means an individual who drives or is in control of a vehicle or who is exercising control over or steering a towed vehicle. Legal entity is a body other than a natural person that can function legally, sue or be sued, and make decisions through agents. A typical example is a corporation. See Black's Law 9th edition, page 976. So the court must be applying legal fiction, as it would have to be addressing a legal or commercial entity with a facsimile look-alike of my name that sounds very similar to mine. Legal fiction, an assumption that something is true even though it may be untrue, made especially in judicial reasoning to alter how a legal rule operates, specifically a device by which a legal rule or institution